Good afternoon, everyone. I'd first like to thank the organizers for giving me an opportunity to present my view in this wonderful gathering. My topic here is a critical analysis on the Personal Data Protection Bill 2006, which is due in the Parliament. As earlier speakers have very clearly mentioned, the moment we say privacy, the legal standing becomes very weak, and more so if it is contractual. I would like to bring into the notice a recommendation which was brought by a committee called Wolfenstein Committee. Of course, that committee was constituted for a different cause in 1957. It was for homosexuality and the determination of age of consent in United Kingdom. But what the committee recommended is important here. The committee recommended that it is not, in our view, the function of law to intervene in the private life of citizens. Now, this is what becomes important for us. The moment we talk about privacy, issues related to privacy, to what extent can law get into the private life of citizens? Where exactly law should stop or start? The committee recommendations to this content, that is the personal data protection bill, would interpret to the sharing of personal information between consenting parties would be out of legal purview. That is, if the person who is sharing his personal information as per a contract, a law cannot get into it for the privity of contract. It would prohibit a third party entering into the affairs of that contract until it is, as earlier pointed out, relating to national security or integrity of the country or issues relating to terrorism. But what we are talking here is not only that, but a lot of other areas like e-governance and other areas wherein personal data are collected in greater detail. We are not only seeing the commercial aspects of the data being collected for benefits of it. Majority of our private data will be in future collected by the governments for its use. Of course, it will be for our benefit also. Now, law here commences only when there is a breach in terms of contract. So, we can say that the power of the Personal Data Protection Bill is only to the extent of the terms of contract. Well, especially this becomes very difficult because now what we have is click wrap and shrink wrap agreements with 60-70 pages of agreements written into a small window. What we see in the computer screens, nobody goes through in detail. So to collect personal details, it is not very difficult. We can say collecting personal information has to be as per a contract. So whatever can be incorporated in a contract can be put into a click wrap agreement, and user will be given just a single choice, that is yes or no. If he says yes, the entire agreement is accepted. So the difficulty for this law when it comes to enforcement is not, it is very difficult at this end. Let us say two ends. One is the law entering into the domain of privacy of individuals, that is one end, or on the other end it is to the enforceability. So here, when it is very difficult to enter into each individual's life for enforcement, the law can get into the other area of giving power to the user by making the law very simple for enforcing. That is, we can take the example of 498A or the Right to Information Act, wherein the law has given so much powers to the individual. So it has not said it has not gone into detailing of what information has to be given and what information is not to be given. It has given power and the simplicity, the ease of enforcement for the end user. As a software has many features like usability, then adaptability, security, even law has features of which ease of enforcement is one. Now, the subject matter of this law is information. Now, the features of this subject matter is first intangibility. We say information. How do we see information? Information is something which is intangible, especially when it is in electronic form. Second one, it is volatile. Then susceptibility and multimedia portability. Now, this and many more, of course, and these being the features of information, if we are trying to say some breach has happened, it is very difficult to enforce at a later point of time, because today if we can claim a breach, we should be able to prove it, let us say 6 months down the line or 1 year down the line. Will that happen in digital era, especially in cyberspace? So now coming on to the ease of enforcement, will we be able to prove, as I earlier said, what has happened today 6 months down the line with the existing enforcement setup, with the police or the judiciary, or the ability of these institutions to appreciate the electronic evidences or the intricacies of information in a soft form. So we can say that we'll have to educate everybody so that they'll understand and we'll get enforcement, but it takes its own sweet time, and we have seen Information Technology Act being passed in the year 2000, and 8 years down the line we have not seen too many decisions coming out of the Supreme Court. So the second line of thought is that we will have a strong concrete line of thought or a jurisprudence sort of a setup wherein we will try to have the existing legal concepts translated to cyberspace. So what we will try to do is, we will try to have something sort of a conception wherein we will call this personal information as a property. This information as a property of that individual. So when we try to see this information as a property of that individual, all the associated legal rights and duties of a property will naturally migrate to this information also, and this will empower the individual. Now, when we start considering information as property, the preamble of this law, giving life to preamble of this law will become very easy. So when the law says, and to prevent its usage by other organizations for commercial or other purposes, and entitle the individual to claim compensation or damages due to disclosure. Now, this, until and unless we have this conceptual framework of a property, becomes very, very difficult, because cyberspace or cyber jurisprudence is very novel in India. We don't have a conceptual framework. For all other areas, let us say criminal law, we have criminal jurisprudence. Civil law, we have plethora of tort related laws. But in cyberspace, we don't have any such concept. So the moment bill gets passed, it becomes an act and it comes to enforcement, people start using it. But once people start using it, if none of the agencies are able to appreciate what is in the law or the individual, the effect of law is literally zero. Hundreds of law may come, but what is the ultimate use? So we should try to make it practically possible the very next day, or let us say 6 months or 5 months within the law comes to action. So when we say information as property, what naturally could happen is, private property becomes absolute property of that individual, and whoever it is disclosed, the person to whom it is disclosed holds that property in trust. So he is a trustee to that information, and any breach would amount to a criminal breach of trust. So let us say, because this act, the main intention of this act, the Personal Data Protection Bill, is to prevent organizations from encashing on the information which they have received for commercial gain with a third party. Organization A should not sell information to organization B of its clients or its customers or whatnot. So, but it is not said how or in what way should it be interpreted. So I try to see it as a criminal breach of trust, so that the agencies also understand, and it is also easy for us to understand. And once this happens, once the owner comes to know, he will have an absolute right to sue. Second one, if such property is misused on the contractual terms, or the possession is changed without the consent of the owner, the third party, if he uses this information, let us say, as per the preamble, wherein it prevents one organization selling its information to another organization, if we try to conceive this information as a property, we can encast a duty that he should not receive that information by making this information as equivalent to in wrongful possession of a stolen property as per the existing law. And any subsequent use of it will amount to a wrongful gain or an unjust enrichment, because he is primarily not having a right to use that information. He is by law unjustly enriching from a third party's information. And this law states that individual has a right to claim. Now, when it says it has a right to claim, how do we liquidate the damages? If we say he has a right to claim the damages, let us say for a vehicle accident, the amount of damages depends on the spare parts or the labor or whatever is associated with it, and that is made good by the a person who is committed that accident or the insurance agency. Now here, how do we translate the amount of losses in terms of money? Though law has given a right, how end of the day as a victim, how do I benefit out of it? How do I claim money? So I feel it is better we make the amount of profits which the organization make by using our money the right for an individual to claim as per this act. Now this, if we try to conceive this information as a property, enforcement is possible with the existing legal framework like Indian Penal Code section 410 stolen property, and as I earlier said, since this information is held under trust, any breach will be should be made a criminal offence, and provisions like 405, 409, 403 and 410 can be used for the purposes of enforcement. I am stressing more on the criminal laws just for the fact that they are very easy to enforce and the procedures involved are not detailed, or let us say they are not too much for a person who seeks to get some remedy. If it is a civil remedy, the onus of providing proof and the onus of providing evidences is totally on the individual. But when we make it a criminal offence, state takes the responsibility and the victim to that extent is relieved, because he has already lost his information, he has already lost his private property. So I personally feel that he should not be again made liable, or he should not be made to go to agencies to take evidences, to try to prove otherwise. So he should be relieved from all these procedural issues. Now, coming on to the words of the law, going by the preamble, as I earlier said, this law enacts only at the point when one organization sells the information which it has to another organization, or this law tries to prevent the transfer of data from A organization to B organization, and until that this law does not activate. I will give an example of terrorists communicating. Now we say emails are sent by A terrorist to B terrorist and we can trace emails. But what happens if nobody sends an email? A terrorist goes and types a mail, saves in the draft, then makes a phone call to his counterpart and gives the username and password. He logs in and he looks into the draft. Now where is the email? Now where are the IP addresses? Now we are coming here, law here is activated at the point of transfer. Transfer need not happen. It is just to drive home the point that transfer need not happen. And in cyberspace, we really do not know the genuinity, because anonymity is one of the elements of cyberspace. We do not know who exactly is behind the computer. All we see is a front end, a visual front end. So, for example, big corporates, let us say a Reliance, who are into entertainment, big TV. We say Big FM. Contractually, Big FM he may give you a call and he would say that I'll give you a chance to talk for 20-30 minutes. Then for that he might take some information. But that contract may be entered by big entertainment corporation which may also, or which also includes big TV, big Gada, then your big FM and all other big bazaar. So next time when you walk into big bazaar, so the moment you swipe your card or you give your details, he might give you a printed record of entire your personal data. Then it would not amount to breach of privacy, because what you have given is for the corporation and not for the individual corporate content. So I'm just trying to drive home the concept of anonymity here. So now it says law activates only when the data is transferred or used by one organization to other for commercial and other purposes. But what if there is a negligent act, spillover of data by acts of negligence? What if there is loss of data due to accidents? And what if there is a deliberate data theft? An organization may file a complaint for data theft against its employees and claim that it has taken all due diligences, or it has taken all measures to see that nothing happens, or all legal formalities are complied, but the loss is made. What happens, and how does the law look into? Law is silent in this regard. Now, section 2C explains that personal data means information or data which relates to living individuals. Now, why only living individual? IPC, when IPC recognizes identity of a dead individual, IPC gives value for the identity of a dead person. It says decent burial is one of the rights a dead man should have. Now, let us say, take the example of Arushi murder case. Some personal information related to Arushi murder case would have been a selling point for 100 media channels, or the Scarlet murder case also. Now, where this data protection, personal data protection bill is silent, I think there should be more provisions to this effect also. Then coming to section 3, conflict as to term processing. The definition of the term processing says obtaining, recording, holding the personal data or information of an individual and carrying out any operation on the information, including alteration, disclosure, transmission, and etc. In section 3 it says the processing, the term processing includes the personal data of any person collected for a particular purpose. The very act of collection itself is defined as processing, and again it is reiterated as personal data not to be processed without consent. Now, there is a conflict on processing and processed. So there is a clarity which needs to be brought into the term the processing and the processed in the very definition clause itself, because down the line in the act, in various other places, the same term is used time and again, and there will be an eternal conflict to this effect. Now, section 3, exception 2. Information obtained through public sources need no permission. Now, what is public source? Is a debatable question, especially in cyberspace. Let us say I am a member in a Yahoo group or a Google group, and I have an identity there. I have some of my information disclosed there. Now, does it amount to a public space? Whether the use of the information which is available there to target me, or to communicate to me, or to call on me, can be called as an information taken under public spaces. Likewise, coming on to the government services, there are about 3 to 3.5 crore government servants in this country. When we say everybody has right, government servants are equally citizens, government servants' information disclosed over public spaces, whether government servants can claim right over this law. You know, their phone numbers, their details are given, whether this law is equally covered, or whether that will become private space or public space. So these are the conflicts which will arise. So there is an urgent need to define what is public space. Public space in terms of cyberspace on the network. So it has to be detailed. And the enforcement agency, data controller as per this act, is more looked into as a regulatory agency. But it would be better if it also acts as an enforcement agency with branches down the line, because as I said, the subject matter of this law being information, it is very intricate to handle. Now with the existing enforcement agencies like police who are overburdened with a lot of bandobast duties and other duties, we can't expect them to understand these problems. So it is better data controller percolates down to the district level with an enforcement agency on one end and the regulating agency on the other end with a setup. It will be very easy to give effect to this law, because subject matter of this law being information, and that information being the information of all 102 crore individuals of this country, enforcement has to come to the district or the magisterial level. Now coming to section 4, the personal data collected by organization, whether government or private, shall not be disclosed to any other organization for the purpose of direct marketing or commercial gain, provided that personal data for any person may be disclosed to charity or voluntary. Now, this word charity or voluntary has the power to ruin the entire act itself, because as I said, anonymity is an element of cyberspace. We do not know for sure who is on the other end. One person may say for charity, but it is very difficult to classify the objectives of the person who collects the information over cyberspace. So this proviso, I believe, should be removed in toto. A person who for charity need not have to borrow information from an organization. If he is doing a charitable work, people will definitely come to him. And why I am stressing on all these areas is the ease of enforcement, as I earlier said, and the subject matter and the people who use it. All the 102 crore people in India, if they should use it. No, they should use it, and if they want to use it, it should be available at their doorstep, and it should be very easy to use. It should not be a remedy which is sitting in an ivory tower, as the Information Technology Act, which has only 1 or 2 police stations centered at 1 or 2 very techno-savvy cities in the entire state, and anything happens somewhere in Chamarajanagar or Shivamogga, everybody, they have to run to the Bangalore cybercrime police station to get remedy, and by the time they come here, the entire material or the evidences will be lost. So that should not happen, because data breach in these areas would not only amount to the loss of an individual, but it would amount to loss of the entire country's information. Individual information is nothing but collectively the country's information. So all these things, I feel, should be taken into account before this law is brought into force, and a detailed schedule has to be given for the people who receive the information, and guidelines has to be given. Regular audits should be prescribed to them, and all these, if they don't comply, should be made a criminal offence on the person who receives it. Thank you.
Thank you very much, Mr. Sudhir. That was very practical and detailed, analytical expose on the personal data protection bill. We'll take these suggestions into account. I've got a lot of time. I'm not going to summarize this as I did the first presentation. Now, may I call upon Sri J. Prasanna, Security Consultant, to present his thoughts on combating terrorism through cyberspace.
Good afternoon to all of you. You might be wondering, why I'm going to speak on some topic like this, in an audience which is actually, filled with people who are, from press, from law enforcement, from, people who are actually studying law. So the reason is, before I start this, from 94 to 98, I did my engineering in Coimbatore. So I was just a normal student, engineering student in computer science. So suddenly in 96, there were bomb blasts. And there are not one bomb blast or two bomb blasts, but there are 46 of them in one single day. And it just continued for next 1 week. When I came outside, in 98 back to Bangalore, I was, looking at all the press, to see if articles were covered about these many bomb blasts, in Coimbatore. nothing appeared really, it was actually said that around 14 people died. So totally around 400 people died in that, and one of them was a very close friend of mine from my college. So till then, for me cybersecurity